What is going on, guys? My name is Mark Reel Jr., the Father's Rights attorney and host of the Father's Rights Playbook. And today we have senior trial attorney at Real Father's Rights, Shannon Wright, on the podcast to talk about your rights as a father when it comes to child custody. How are we doing today, Shannon?
I'm doing well. How are you doing?
I'm good. So one of the most common questions that we get asked is, what rights do I have? Because the common situation is mom leaves with the kid, mom kicks the dad out, dad's not seeing the child. So for our listeners and viewers, can you walk through kind of those initial questions when a dad comes to us and says, do I have any rights?
Yes, and I would start out saying that it depends on your situation of what your relationship is with the mother. For example, are you married to her, or are you just in a relationship and now the relationship is ended and the child was born outside of a marriage? First, let's talk about what happens if they are married. So it's kind of like I like to put it as like a game of chicken crossed with tug of war. Both parents have equal rights to that child. There's no hierarchy. Yes, oftentimes women think that they have a hierarchy, like, I'm the mother, I get to decide, I know what's best for my child. Well, you know what? So does he. Yeah. He gets to have that, but legally speaking, they are on the same level playing field.
Because when the child is born and you're married, there's a presumption that the husband is the father.
Yes, and it's all of the same rights and responsibilities as each other. Now, what you would have to do if you're splitting up with your spouse in this situation is that to enforce any of those rights, because if you're not coming to an agreement, you need to have that record breaker. You need the court to be involved. So you have to, one, file a petition for dissolution of marriage. That just creates the case. On there, you'll be putting on there what you want regarding custody and visitation, but that's not orders. It could potentially become orders if there's a default judgment because it'll match that, but it's not orders. You have to then file a request for order to establish child custody and child visitation, and then it'll go for the court, which I want to warn you. You want to act on this as soon as possible, because once you file this, it is very common for the court not to even schedule you for 3 months.
Yeah,
they can do it longer too.
Yeah, depending on the county. We've gotten through the COVID stuff. At times during COVID, it was 9 to 12 months with some courthouses.
Yeah.
But now we've gotten it where you're usually somewhere 60 to 120 days.
Yeah.
But like you said, mom and dad technically both have 100% legal and physical custody. So until you file a case and then until you get orders in front of a judge, either party can do relatively whatever they want.
Yeah. And I will warn you that, say mother takes the kids and moves out. She establishes her own residence. You can't go into her home and say, I want my kids, I'm taking my kids. You're trespassing. You are possibly even breaking and entering. You can't do that. She has her own place. You have rights and access to the children, not to her place. So if she has the kids locked up at her place, at her home, you can't enter it. If you go to the police for this, they're not going to do anything because you don't have any orders to enforce.
Well, then also, if you move out, which is something common we see, I always tell the guys that I'm working with that it's usually not a good idea to jump right into another relationship. But we see it. We see it. You immediately find another girlfriend. I've seen some of them get engaged. Some of them get married very quickly. Yeah. And you move out of the house. Well, just because you used to live there doesn't give you the right to come in there and do whatever you want and get the kids.
Yeah, because it's there are things such as where the person who stayed behind can get an order for exclusive use, but technically it's not required. I've seen plenty of situations where, for example, the man moves out, the wife is still living there, the kids are still there, the guy tries to come back like months later, coming and going because she never changed the locks, which she doesn't have to, and actually it can be used against her if she does. But he's coming to get his stuff. He's interfering with the new life, the new status quo that's been created by him moving out. And I've seen it where she uses that information that he's just coming in willy-nilly on his own without permission, without notice, without anything. And she'll file a domestic violence restraining order using that.
Judges don't take too nicely to that.
They don't like it because you established a status quo of you no longer in that home. Even if you're on that deed, you have now, think of it as a landlord. And that the landlord can't, they own the property, but if you're renting from a landlord, that landlord cannot just go into that home.
Yeah.
You have your privacy. She has her privacy. You cannot just go and do that.
Yeah. All right. So if you're married when the child's born, presumption you're the father. I think it's a whole nother episode we can talk about if you don't think you're the father.
Yes.
Which we've had a few of those where divorces don't get finalized. Mom's already had another kid. Creates a whole nother set of issues. But like I said, that'll be a different episode. The other part, and what's becoming increasingly common, it's ballpark about 70% of kids are born to parents who are not married. So a child is born to parents that are not married, and let's say dad's there in the hospital. At that point in time, does the dad have any rights?
Just being in the hospital, not doing anything else, no. He's not a legal father. He's, they can argue he's presumed if something happens like juvenile dependency and she names him, but that's presumed is not the same thing as legal father. If he does sign the birth certificate and essentially there's an affidavit that both the mother and the presumed father can sign, that will make him the legal father. However, with that, signing that and acknowledging that this is your child, that assigns you responsibilities to this child.
Yeah. So it's signing the document. So you'll hear a bunch of terms for that. VDOP, voluntary declaration of paternity. I guess the lay term is I signed the birth certificate. I'm on the birth certificate.
Yeah.
And if you're on the birth certificate, you have the same rights as mother. It's as if you were married.
Yes, but they treat it differently. It's really, you're coming back to this. They're just now, even though, as you said, 70% of children are now born outside of a marriage rather than being in a marriage when they're being born. And up until it was we're now in 2024. Up until at a point in 2023, the courts were making paternity cases private. No one can access them, not even the attorney on it. It was not online because of the stigma, like, oh no, clutch your pearls, a child was not born inside of a marriage. Yeah. And that's been old news and more common to be born outside of a marriage for a long time. And so finally the courts are starting to recognize that by making those public, just like divorce proceedings. But they're still not treating fathers the same. When you do sign the birth certificate, you get your last name put on the child. That child will be able to bear your name. But really, in practical sense, all it's really doing is giving the child your name and giving her the evidence she needs to now go to child support and get you put on child support. That really is all it's doing.
Yeah, because here's the thing, and we see this, unfortunately, far too common, is the voluntary declaration of paternity will be signed, the father's on the birth certificate. The hospital staff is going to do everything. They're not going to separate the child from mother. So no matter what happens, that child is going to be with mother. And if mother says, I don't want father in the hospital room, and most hospitals won't let a newborn out of the same room as their mother, then she can keep you, even if you're on the birth certificate, away from the child, can go home. You have very little say.
Yeah. Well, at the hospital, the mother is the patient.
Yeah.
And technically, once the child is born, the child is a patient, but they still treat it as the mother being the patient is the trump card over the child and kind of extend it to the child. So again, she can say, no, I don't want that man in here. This is my time with my child. I just don't feel comfortable, or whatever reason, doesn't want him in
Usually
there.
it's big bad man, I'm scared of him, he abuses me.
Yeah.
You get all the allegations, and the hospital staff will always side with the mom.
Well, and you can't really blame them for that. They have no idea, and they know that she's just going to be here for a day or two, and they rather just be safe than sorry and not have to deal with that mess themselves. What if they let somebody in? Now they're liable if someone gets hurt.
So it's similar to law enforcement getting involved in custody exchanges.
Yeah.
Should they? Are there rules that govern this? But it's a lot of times it's either above the training or beyond the risk that a hospital is willing to take. So let's talk about the third scenario, and that is child is born. Another very, very common. Child is born. Parents are not married. And father is kept out of the hospital. Father is not allowed to sign the birth certificate. What are his rights then, and what does he need to do?
Okay. Well, he would then need to establish it. So he, again, whether it's on the birth certificate or not, he needs to file a petition to establish parental relationship. That is what establishes what's the jurisdiction for the court to even open a case and then at some point make orders. Again, like the petition for dissolution, you put on there what orders you're wanting, but again, it's not an order until there's if it were to happen, a default judgment under rare circumstances. But you still then have to file a request for order.
Good luck enforcing that.
Yes, because they want to overturn those even if you did a default correctly and all of that.
Especially on the custody piece.
Yes. So if he has not signed the birth certificate, he will still file the petition to establish parental relationship, but he'll check a different box saying that he wants to have a DNA test. DNA tests usually trigger in people's mind that they're challenging it, but it doesn't have to be.
It's
if
either
she's
DNA
denying
test
it,
or
yeah.
a stipulation.
Right.
So unless she agrees,
Yeah.
there's going to be a DNA test.
Yes. So unless she's acknowledging it, so he can put on there, I'm the father, I'm the biological, but it'll ask you if you signed the birth certificate and things like that. So
FL 235 is the voluntary acknowledgement. We don't need to get into judicial council forms, but there's a specific form
Yeah.
that both parties have to sign, or it's going to go to a DNA test.
Yes. So she can challenge it saying, hey, I don't know if he's really the father or he's not the father, and it'll end up being a DNA test. The only way that will not is if the parties on the record agree that he's the father. So once you get past that hurdle, then you will go into like the rest of the request for order to establish custody and visitation, which, by the way, on any of these, whether it be a divorce or a paternity petition, if you're filing for a request for order that regarding child custody and visitation, California sends you to mediation. Now, it varies county by county to how much they'll do with that. Like, for example, Orange County and LA County, they are very much minimalist with that.
Non-recommending, I think, is
Correct.
the technical term they use.
And what that means is that when they set up mediation, they have their individual processes. If they have you do paperwork, how much paperwork and all that first, but essentially you'll go to mediation. They will try to work out an agreement. Some depends on how hard they'll try, the mediator, but essentially it'll end up being, if there's an agreement, they'll type it up, have the parties sign it, move on. If there is no agreement, they'll just do a memo to the court that says no agreement reached and move on.
Yeah. And some attorneys will recommend, if they know there's not going to be an agreement, that you just tell the mediator in non-recommending counties that there's no agreement and that you're not going to agree to what they want and leave.
It saved people time,
Yeah.
I explain to my clients that you have to at least go through the hoops, see if there's something, but you don't have to agree to something that you're not comfortable with or is just too far extended. We have court for that to argue to the court. Now, in other counties that are recommending ones, which is, for example, Riverside and San Bernardino counties, then those, they again go to mediation, and you really want to be very clear about what you're wanting and why, because they will interview you. And if you come to an agreement, yes, they'll type that up, whether it be a full agreement or a partial. But anything that is not agreed upon, they will make a recommendation to the court.
Yep.
And you won't really know what that recommendation is until oftentimes the day of court, because they're not always getting that report to you until you show up. That report, now, it's not the end-all, be-all. You still have some abilities. The court will, at least pretty close to that, make temporary orders.
I will say that's usually the starting point.
Yes.
The recommendation is the starting point. And in my experience in Riverside and San Bernardino County, it's less mediation and more it is a counselor that is going to make a recommendation. If you guys come out and agree right away on something, I've never seen them go too deep into attempting to come to an agreement.
I've seen a few, but it's definitely
there are
minority.
good ones. There are good ones. There are
Yeah.
really good ones. You may get lucky, but a lot of times it's, what do you want? What do you want? Okay, awesome. Why do you want it? Why do you want that? Okay, bye guys.
Yeah, and you definitely have to offer up the information yourself when you're being interviewed, because they're definitely not going to go very deep. They're not treating this like a true investigation. They're just like, okay, what's your arguments? Give them to me. And then that's it.
They have, I think it's a max of an hour, and usually they don't spend near an hour, and they're going to do 6 to 8 of these in a day.
Yeah.
I mean, you're just like with a court hearing, you're 3 months out for an appointment with one of these family court services people. So,
and they don't always, sometimes the mediator might look at the court record and what people filed, but not always. They're not required to either.
Yeah.
So I always recommend on those, have your bullet points of what you're wanting to talk about and what you want them to know so that you don't forget, because otherwise they're kind of going to rush you through these. But the next step, once you get the report, you can either the parties can agree to the recommendation, or they can, what they want to do. They want to fight this. If they want to fight this, they need to ask for what's referred to as a Family Code 217 evidentiary hearing. It's a certain document you file. You can ask for it orally, but you'll then have to follow up with a written list of witnesses if it's more than the two parties. But then they'll schedule for an evidentiary hearing. You get to challenge it. I always do recommend calling in the mediator as one of the witnesses.
Those can get interesting.
Yes, but I'm of that position whether it is the report went your way or against you.
Yeah.
Because if it went your way, you want them to repeat that. If it went against what you're wanting, you can then challenge them on it. So you'll go through the going, well, what about this information? What about this information? Do you really bring out this? If you knew this, would you make the second recommendation? And so on. So either way, I would call that person as a witness. Yeah. So, and then after the court has the evidentiary hearing, they'll make orders. Now, bear in mind, any order that's made from a request for order, those are officially temporary orders unless said otherwise. You still have to finalize these cases with a final judgment on those issues. Yeah. So,
awesome. Well, a lot of information. Thank you so much, Shannon. So the short version for dads, if you're married, you're presumed the father, and you legally have all the same rights as mom until there's a court order. For those fathers who are not married, the question is, are you on the birth certificate or not? If you're on the birth certificate, you technically have the rights, but it can be challenging to enforce them without a court order. If you are not, you have no rights. So I hope you found this episode informational and informative, and I will see all of you guys on the next episode of the Father's Rights Playbook.